Good evening, everyone. Patriot Smoothie here to talk to you about day 24 of the Tamara Lich Chris Barber trial. It was a pretty big day in court today, so make sure you follow this one to the end. You don't want to miss it. As you know, there was a request, an application from the defense last week because of a series of disclosures that came about when Officer Bach was under cross-examination. The court learned, out of surprise to everyone, that Officer Bach had lost the content of her phone. She had done an update to her phone, which caused her to lose her phone's content. This came out during cross-examination, and there was a subsequent request from the defense teams to have the instructions provided from OPS to officers disclosed so that they can know what, if any, steps Officer Bach took when she did that phone update to preserve the contents of her phone. Those contents, as a reminder again, OPS Officer Bach was the primary contact with Chris Barber, so she's a significant witness in this trial to the alleged allegations against Mr. Barber and through the Carter application, Mrs. Lich. So as we know, she lost her phone data. So the defense wanted that information, the set of instructions that she received, that OPS issued on how to do this phone update. As she testified, she tried to follow these instructions. She was unsuccessful and subsequently lost the contents of her phone. We also learned previously, through disclosure months ago actually, that OPS PLT officer Sear also lost the contents of her phone. So the judge remarked at the time it was unusual to have two PLT officers having their phone contents wiped. That's the word she used, wiped. And today we got a ruling on the requests that the defense had made. The defense had made multiple requests. They requested again that information from OPS about the instructions that they gave to officers on how to update their phone. And so I guess they could see where things were lost, where things went wrong, what the timeline of all that was. They also requested the instructions given to PLT officers at large in regards to disclosure. And in response, they got a series of things. They got what we now know as Exhibit A, Exhibit B, Exhibit C, and Exhibit D. And Exhibit A, for a while, it was just basically a series of redacted emails and documents that are almost entirely redacted. I remember at one point, Justice Heather Perkins McVeigh some time ago held up one of these documents in court and said, "What am I looking at here? This is completely blacked out," because the defense passed it up to her for her to see how redacted it was. And she pointed out to the court that it's not inappropriate for her to have it because there's literally nothing she can see on there. You have to remember that this is a trial by judge, so she is the fact finder as well. She's basically the judge and also performing the role of a jury. In a jury trial, it's potentially possible that with all these Exhibit A, B, C, and D that are totally blacked out, she could have excused the jury, and without these incessant legal arguments that have taken days and days and days, she could have looked at it possibly and decided whether or not they were clearly irrelevant, whether or not they were solicitor-client privilege. But because she's also the fact finder, she's going to determine the innocence or guilt of the accused. She's got to be more careful in how she approaches this. Is more or less what I was told by one of the lawyers in the courtroom when we have these discussions every day to try and basically search each other's minds for how things are going. And it's really interesting to speak to someone with that kind of experience. And I add my opinion, which isn't learned, but it's interesting because you watch it, and we get back and forth and develop a couple of the ideas there. And eventually, I think I'm going to have them on the show. But in the meantime, I appreciate that exchange when it happens for the information it allows me to develop and to obtain. So that's an interesting perspective. So we've had to endure these legal arguments. And again, last week, Justice Heather Perkins McVeigh indicating that she would be ready possibly to make a decision on one of the arguments that the Crown has made. So the Crown gave three reasons for why they'd made these redactions. One was clearly irrelevant, two was solicitor-client privilege, and three was litigation privilege. Now, Justice Heather Perkins McVeigh indicating last week that she'd be ready probably sometime this week. There's trial today, Wednesday, and Friday, so 3 days of trial this week. There was none Monday and there's none Thursday. That she'd be ready this week to deliver a ruling on the clearly irrelevant. We got a surprise today. She delivered a ruling on everything, and it went very well. Keep watching. I'm going to tell you how it went, because I think that even though today was a late start, we started late, I think it was a good day, but I just want to get back through the rest of the background before we get into what happened. So again, there was that request from defense because of these redacted documents for those instructions given. So Bach testified, cross-examined, comes out that her phone's been wiped. The defense, second step, the defense then makes their request, okay, we want to know what she was told by OPS to update her phone, and we want to know what all PLTs were told regarding disclosure, because something I forgot to mention on the background, Officer Bach testifying that she had signal on her personal phone. So they wanted to know, basically, as you recall from earlier in this trial, there was a lot of back and forth and issues. Signal chat wasn't disclosed between the PLT officers until the middle of the trial, until the trial was well underway. And Justice Perkins McVeigh has said on the record that that's caused delays too. So, the defense wanted to know what was given to them in regards to disclosure at large, because why didn't she disclose that she had the signal on her personal phone, and what was given to PLT in regards to phone updates, because how did she wipe her phone from a phone update? We have 2 officers now who are alleged to have lost phone content due to a phone update. The only reason we have Officer Bach's text with Barber is because they were recovered from Barber's phone, but there could be other text between Officer Bach as a PLT and other contexts in the Freedom Convoy that can change the nature of the facts in this case with Barber, and in other cases as well. And there could be other things on there besides just text messages. There could be documents, there could be whatever. We just don't know. So they wanted that, and they got this series of documents that were totally blacked out. And we know in some of them there were emails. We know in some of those emails there were emails between seemingly 2 police officers, or a police officer and a group of police officers. And the 3 reasons given for the redactions, again, clearly irrelevant: solicitor-client privilege and litigation privilege. And we went back to that. So the defense made this request to the court, because we have these 4 exhibits. The court, they requested basically third-party application, because the OPS declared that some of this, and the Crown, declared that some of this was a third-party request because they had received inadvertent disclosure from the police. Some of this documents that they redacted as clearly irrelevant were given to them inadvertently by the police, and therefore are a third-party application, a third-party document that they shouldn't have had, but they have now. So the defense approached it from different angles. Basically, if it's not a third-party document, go down this way. If it's a third-party document, go down this way. Multiple applications from the defense. But the objective of the defense's applications in regards to these redacted series of emails and documents they got in response to the request for this information, the defense's strategy was just basically to unredact them, or to get them in their hands, or at least into the court's hands, so the court could properly determine whether they were clearly irrelevant, whether there's solicitor-client privilege, because in some of these emails and documents, there's solicitor-client privilege claimed between 2 apparently non-solicitors, and there's basically no example in case law, criminal case law in Canada, from what I understand I'm hearing in court, that this is a novel issue where case law is being claimed between 2 police officers, 2 potential witnesses in a trial. The OPS counsel actually came forward and made an argument saying that this is actually an officer disseminating legal advice from the Crown to other officers, so therefore it's solicitor-client privilege. Now we know there's 3 criteria according to the SCC, Supreme Court of Canada, where solicitor-client privilege can be claimed. It's a person who's seeking a legal advice. It is intended to be private, and I forget the other criteria. It's for the purpose of seeking legal advice. The venue is private, and it's between a solicitor and a client. So those are the 3 criteria. And so obviously we don't have between a solicitor and a client here, but we don't know how far that goes. There's case law where it's like, okay, once advice is given to an attachment, the privilege, once a case law or advice is given in a document, the privilege attaches to that document, and so on. And it just goes in different ways. There's civil law. So to the good news. Today started late. We started around, I'd say, we were supposed to start at 11:15. Miss Eunice for Mr. Barber defense had another matter, but she didn't actually get out of court for that until 12:15. So we started at 2. We didn't start. We were in court. We got back and we got in session briefly around 12. They said, no, we're going on lunch, or they just said we're going on lunch. Then we got back at 2, and at 2 we got a big surprise. We got a win. So what happened is Justice Perkins McVeigh came in and delivered her decision on both issues, both the issue of the irrelevance issue and the solicitor-client. So going back to those redacted documents, as a summary, we have what has been now called Exhibit A, Exhibit B, Exhibit C, and Exhibit D. That's the series of different redacted emails and documents. In A, so let me just go through it. So D, the Crown explained that it's because they were asked, I believe, on Friday to explain, okay, summarize each of these documents and their main principles, basically. So for D, they said it was litigation strategy and a legal application for a case that's not involving this. So litigation strategy for Exhibit D for those redactions. And then the defense was happy with that. They were no longer interested in pursuing Exhibit D. The judge at the time remarking, why didn't you just say that from the beginning? We wouldn't have had to argue about this so long. So then there goes Exhibit D. Now, all of a sudden the defense doesn't want it. Then Exhibit C, which is the main focus. Exhibit C, I understand to be a series of emails between Those are the emails between PLT officer and other PLT officers. So between Sergeant Feng Li and a group of PLT officers, and between Sergeant Feng Li and Officer Bach, and so on and so forth, between police and police, and not solicitor. Those are the ones that the OPS is claiming solicitor-client privilege on in Exhibit C. So those are part of this application. Then there was Exhibit B. Exhibit B is an email, I believe, that was redacted for clearly irrelevant, because the Crown explained that it was a question from the police about who's the new Crown on this case. There was a Crown shuffle at some point, I believe, on the Lich Barber case, and so Exhibit B is an email talking about that, and the defense accepted that, so they no longer wanted B. They didn't want B. As I understand it, they did not want D. They wanted C, which is the emails between the police officers, which the subject of those emails are PLT disclosure, stuff like that, and it seems to be between PLT Sergeant Feng Li and PLT Officer Bach, and other email between Feng Li and a bunch of PLT officers, assumably all of them. And then there's Exhibit, so they want C, those emails. And then there was Exhibit A, which I believe is the instructions on the update. Now, the A was the one that they said all of it's clearly irrelevant, but those are the instructions on the phone update, as I understand. So the ruling. Perkins McVeigh coming back, reading her ruling, citing Stitchcomb, citing O'Connor, citing their progeny cases of those, citing Supreme Court of Canada on solicitor-client, even remarking at one point that solicitor-client privilege is the bedrock of the justice system in Canada. And we know from the defense's application that they said that they would not pursue piercing the veil of solicitor-client privilege if the court were to decide, if Justice Perkins McVeigh were to decide that it's solicitor-client privilege, the defense would not seek to pierce the veil of that. And so they just wanted to know what it was. So Perkins McVeigh ordered, this is the first one, she ordered that the Exhibit A and the Exhibit C be handed to her in sealed envelopes, and that was a win. That was the first win. So they did that. So the Crown requested a 5-minute time to conference with the Ottawa Police Council, and then they did that. They prepared 2 envelopes. I believe it was a silver or a white envelope, silver for Exhibit A, and a yellow envelope for Exhibit C, and those were given in a sealed envelope to Justice Heather Perkins McVeigh. And we then went on recess. She went to her chambers, and she went through there. She went and read them. She came back after that, and that took maybe 10-15 minutes. So her ruling took about 20 minutes to read. I reported again, as always. If you want the nitty-gritty details, sorry guys, I'm not feeling too great, go on X and read them. She took about 15 minutes to read those 2 envelopes, the sealed envelopes with the 2 exhibits that the defense wanted, and she came back and she ordered the release of Exhibit A to the defense, saying that it may be pertinent both to the credibility of the witness, Officer Bach, and that it may go to some of the questions that she was unable to answer. So she's ordered Exhibit A be given in full, as I assume, to the defense. So that's interesting. Now, with Exhibit C, the emails claiming solicitor-client privilege between PLT officers and other PLT officers, other police liaison team officers. She said she needed more time with that. We then had about 15 to 30 minutes of evidence in chief from the Crown with Officer Bach, and in that period, they finished up with Officer Blondie. Officer Blondie, spelled Blonde. So they finished up their evidence in chief with him, and they asked him questions like, were you there on the police clearing operation? What did you see? He said he saw people getting arrested, yelling, people pushing, that the POU, the public order units, were pushing people, he said in air quotes. He said that he observed peaceful non-compliance or something like that, where someone was sitting in the middle of Wellington Street and who got arrested because they didn't listen to the POU. As he testified, they moved slowly and methodically westward on Wellington from Rideau, Sussex, towards the rest of the Wellington Street to Metcalfe, O'Connor, down Metcalfe to Sparks, and so on. He said that on the 18th they went from Laurier and Nicholas up to to Rideau, Sussex. They stopped after clearing Rideau, Sussex for the 18th. Then they re-began the clearing operation on the 19th, and made their way down to Sparks and Metcalfe. And he observed that people, pushing, not moving out of the way, sitting in the road, getting arrested for not moving. And he talked about the messaging he delivered, the flyers that changed colors, I believe, starting with the blue one on the 16th and the red border on the 17th, the leave or you'll be arrested messaging that they handed out. He talked about actually going up to people, talking to them, telling them what's going to happen if they don't leave, that they'd be arrested. He talked about specifically speaking to his contacts that he developed on Metcalfe and Wellington and so on, and telling them, and he even described them in his testimony as being hell-bent bent on being arrested. He was reminded at that point by the Crown to not focus on what people were thinking, only on what he observed, and he went back to saying he observed people being arrested, a lot of people being arrested, and some yelling and such other things. So we finished with that, and then it was the defense. So the Crown finished their chief, said that, hey, we might have some more to talk about. Now, mind you, this is after the rulings that went in the defense's favor. The first ruling, of course, that these things be produced to the court, which they were, these two exhibits, A and C. And the second ruling after the break, that the judge came back and said that Exhibit A be given to the defense. So that was the second one, and with Exhibit C needing more time. So now it's about 4 o'clock, I'd say, and the Crown's like, okay, well, we're done with the witness. The defense can go and cross-examine now. And then the defense was like, we're not ready to cross-examine. We don't want to cross-examine these last two police witnesses until we have these documents, or we have a decision on these documents, because if we get these documents, they could very well change our cross significantly. So we're going to wait to do that. And that's what happened. So the Crown, there was a break for the Crown and the defense to have a meeting. And also, actually, the judge asked the Crown and the defense, all counselors, to come and see her in her chamber, I believe, or the hallway out where the judges go to. And that's what happened. So we came back, and the Crown said there's been an agreement. We are asking to adjourn until tomorrow at 10 in the morning. And so that's what we're doing. I don't know what's going to happen tomorrow. I don't know if we're going to get a further decision concerning Exhibit C, those emails between two police officers or more than two police officers where they're claiming solicitor-client privilege. If we're going to get the decision on that, we did get the decision on A, which is good news. A was to be given to the defense by today. Basically, the Crown said they'll do it today. And that's interesting. I think today was a big day. It was a win. It was a short day, but significant progress. And I'll keep you updated. Thank you so much for following on Patriot Smoothie.